Okay, so I'm Michelle, and this is Jay, and our biographies are in the booklets. And at this workshop today, we're going to be doing two different topics. We just could not decide which one we thought was more important to do with our hour. So I'm doing demolition evictions, which is a way to get rent-stabilized tenants out of the way to do a project. And Jay is going to do source of income discrimination, which he'll tell you more about in a minute. But it's basically, you have to take Section 8 tenants if I just wanted to do it in an elevator speech. So let's start with the demolition evictions. Okay, so we're talking rent stabilization. So in rent-stabilized buildings, demolition eviction is a way to not renew the tenant's lease if you're going to demolish the building to build something else. So the first, well, let me say this about the materials. I make the materials to be much more enduring than just the half-hour lecture. So, I mean, I couldn't possibly cover all the detail. This is designed to be a resource. So I took the statute, I took the DHCR operational bulletins and fact sheets, I took all the case law that's out there, I took anything I found in the media, and then just practical advice, and I organized it here in sort of like a step-by-step, checklist of what you would do if you were really considering doing a demolition eviction. So the book is good, and it'll be up on the website shortly, too, but you can always contact me, I'll send you a PDF. So from page 3 to 4, I sort of rant about rent stabilization, which you don't need my personal opinion, but all you really need to know is that earlier this year, Herbert J. Sukenik got $17 million. $17 million as a buyout to get out of his rent-regulated apartment. And he got a $2 million apartment that he pays $1 per month for the rest of his life. Now, he got this from Zeckendorf for 15 Central Park West, and he was the last tenant in the way of the project. But what I've personally seen is that now every tenant in like Park Slope thinks, that when there's still 6 other tenants left in the building and the landlord doesn't even know if they're going to develop it, thinks they're going to get $18 million. So I honestly think the $17 million buyout is a sort of a game changer. Last year, when we came to the Brooklyn Real Estate Summit, I did a book, which is on my table in front, called Buyouts, Making Them Happen. And we were talking about how you combined using, hardcore but colorable litigation tactics together with kind of carrot stuff, like stick and carrot stuff, win-win situations that helped tenants transition out in a humane way that put them somewhere that they were happy about being. So that was last year's book. And I was looking at the book, and I saw that I mentioned in there ways to create pressure. And I talked a lot about non-primary residents. But I mentioned demolition eviction quickly, and I said, demolition eviction, it's an option, it's in the law, but it's expensive and it's time-consuming and it's hard to get. So I'm not going to talk about that a lot as a way to create pressure. So what's changed? It's still hard, it's still expensive, and it can still be time-consuming. But what's changed is I've looked more closely at it because I've had clients involved in it and I spent some time on it. And also, when you have people thinking they're getting $17 million, you have to, necessity forces you to look at other alternatives. So, demolition eviction. Okay. I also put the fact sheets and the operational bulletins and the actual statute in the back, too, so you don't just have to take my word for it if you want to read it all. So demolition eviction, it's one of those grounds you can use to not renew a tenant's lease in the Galub period, in that 150 to 90 days before the end of a tenancy, when you have to send the renewal lease. That's when you would send a notice saying, I'm not renewing your lease, for like non-primary residents, or in this case, because you're going to demolish the building. This is one of those things that you need the New York State Division of Housing and community renewal, DHCR, you need their okay on. You can't just go to housing court on this. You got to go to DHCR on this. So wait. Okay. On this slide, Catherine, I'm just going to do it in a different order. So just like bring it all up, I guess. So now I'm going through. Okay, so like page 5 to about, I don't know, 16 is boring. It's just very boring because it's dry, because I'm actually putting, you know, the details of the law in there. But I'm going to hit the high points. Like I said, if you're seriously considering this, you'll read the book. All right, so you need the permission of DHCR. You need proof that you have the money for the project. So you need like a commitment or a letter of intent. And one thing I should mention here that I've seen in the case law that can be tricky, when you guys are developing buildings, I noticed that there's like 19 LLCs floating around and there's transfers happening and, you know, I don't know what anybody's doing. You have to make sure that the entity that's the ownership is also the entity that's getting the financing and that's on the commitment, or that you can show identity of ownership between them. So that's something to keep in mind. Also, you have to have approved plans from the city. And it says approved plans from any relevant agency. So I think, I haven't had this particular situation, but I would suspect that that means more than DOB. It probably could mean landmarks or DEP if you have environmental stuff. So now, those are the big things. What I'm selling today is the idea that if you know that this is an option that can really clear a site so you can develop it, you might change the order in which you do things so that you work with your architect and with your lender so that you get these things in place earlier so that this becomes an option. I was even toying with the idea of, could you get some kind of financing that had a contingency built in for you getting vacancies? The possibilities are endless, and that's part of what I'm trying to do. By really going into the law and telling you exactly what you need to do, the idea is to like open up all our minds to creative ways to put it together and do things. Okay, so what do you have to do? All right. I'm going to work backwards because I thought about it later, and it comes out better this way. Okay. Number one, you have to pay the tenants reasonable moving expenses. That's not the end of the world. A lot of people would pay reasonable moving expenses if it meant that they could get a tenant out of the way. Number two, you have to pay them a stipend of $5,000. That's also probably not the end of the world. But the devil is in the details, and this next point is where I think is the sticking point for a lot of people. You have to either, and this is the landlord's option, relocate the tenant or pay the tenant an additional stipend. And the additional stipend is kind of a lot, and it's pursuant to a formula sheet that DHCR puts out that's part of their operational bulletin 2009-1 that's in the back here. And I'll give you an example of that in a minute. So let me work backwards. So the paying the additional stipend, that probably sounds good to a lot of people because you don't have the relocation issue. But like I said, it's a lot. The example I have in the book is if you have a 6-room apartment that the tenant's paying $1,000 a month to, I think the stipend is almost $2,000 a month, and you have to pay that for 72 months or 6 years. So it comes out to like $140,000, I think. Which, I mean, I guess there are situations. Again, it's all situation specific. That's why I just want to put the information out there. There are times when a $140,000 buyout, you know, would make a lot of sense. But here's the catch on that one, and it's sort of buried. If the tenant is getting some kind of government benefit that the payment, this extra stipend, would raise their income so much that they lose their government benefit, then the tenant has the option to say, no, 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 I don't want the stipend. You have to relocate me. Which I really can't figure out, like, now you're getting enough money that you don't need benefits, but you don't want that. But I mean, I guess it's complicated and there are a lot of social issues. So the point is, It says at the beginning of the statute that the landlord has the option of the additional stipend or the relocation, but you don't really, if you have a tenant in there receiving any kind of benefit, then they can nix it. So let's talk about relocation. Okay, under relocation, you have two options. You have permanent or temporary. I'm going to do temporary first because it's easier. You can say to a tenant, I'm going to move you while I build this building, and when I'm done with the building, I'm going to put you back at the same rent. Now, that might not sound great, but as I get to examples later where, if you're moving them out of a 6-unit building to build a 70-unit building, and you have to have some subsidized housing anyway because of your tax abatement program or whatever you're doing, that might not be the craziest thing in the world. I wasn't able to find any case law on details on what the standards for temporary relocation are, but I'm going to assume that they're the same as permanent relocation. You can't put them in a terrible place. And the rent would have to be the same, et cetera, et cetera. And also, I'd also be curious, what if you temporarily relocate somebody and promise you're going to put them back in the building, and then the building isn't done for 6 years? Like, that I don't know about either. But it's just something to keep in mind. The permanent relocation, which is probably where most people will go. So here are the standards. It has to be suitable. What does suitable mean? It has to be the same size, same features, same services. It has to be in a building that's almost violation-free, and it has to be at the same or a lower regulated rent in the same neighborhood. And I know that's where the devil is in the details. That's a lot. But it's not, but just follow me. So also, one thing I want to say is it doesn't have to be, though, that you put them in another rent-stabilized building. If you can somehow put them in a situation where you contractually make it so that they're in the same position, then that's okay. So for instance, if you owned a condo and you put them in there at the rent-stabilized rent, that would work. Okay, so those are the basic requirements. Oh wait, a few more things I want to say. Okay. All right, so why you go through this application process, you can't get rent increases. And there's been a lot of litigation, well, not a lot of litigation, but there's been very serious litigation now over the issue of what is demolition. So on page 15, I go in detail into the Peckham case. And that is a case that I think is instructive just because it worked and they were able, let's see, what did they get out of the way? It was a 40-foot deep, 3-story, 8-unit rent-stabilized building in Manhattan, and the owner wanted to build 70 feet deep with 12 units, and the owner won. Peckham started in 2004 and resolved in the landlord's favor in 2009. So, I mean, that's 5 years. But that shouldn't scare you too much in the sense that that case went all the way through DHCR, through the lower court, and all the way up to the Court of Appeals, the highest court in New York State. So it doesn't get any more intense than that, and it lays down some very nice precedents, such as there is no definition in the statute or at DHCR of demolition, and the court says there doesn't have to be. So demolition doesn't have to be razing to the ground like whatever was there is not there anymore. You can keep the shell and replace building systems, partitions, plumbing, floor joints, subfloors, that kind of thing. But you can work with a shell. Also, this case is a case the case that said you don't have to have the same two LLCs on financing and on ownership as long as there's an identity of interest between them. So I put a lot about Peckham in there because it's very instructive and there's not a lot else out there. Okay, so this is the real meaty part. So I was thinking about this. Now I'm going to give you 3 examples of how this might work. And I know somebody's going to say, well, but I don't have that, and what if this happened? And you can always throw a fly in the ointment. The point is to use the material and to use the tools in a way to think creatively that, hey, this might work. So this is just me thinking about it, and I don't have a building to develop. Okay, so an owner owns many rent-stabilized buildings in Bed-Stuy. He wishes to demolish and redevelop one of them. He buys out most of the tenants, but 3 tenants just won't leave. They're your 3 holdouts. So if the owner sets aside 3 vacant apartments from his other rent-stabilized inventory in the Bed-Stuy neighborhood, And he makes sure that that building is virtually violation-free, which he probably should anyway. And then he can apply for a demolition eviction and offer relocation to those tenants. I mean, it's an idea. Okay, example 2. Okay, in the immediate vicinity of a project in Clinton Hill, an owner buys a 1-bedroom condo. And I say in the example, or a co-op that you're certain you can perpetually sublet, but I don't know if that exists anymore. So you buy a condo, let's say it costs $1.5 million, and you have carrying costs. And then you put the tenant, your one holdout tenant, you stick him in there. Now, that would work very, very well for especially an elderly tenant who might not be there forever. And you might say, like, oh, so Michelle, I'm still spending $1.5 million plus closing costs. But the difference is, would you rather give 6 figures to the guy, or would you rather put 6 figures into a piece of real estate that will appreciate? And when the elderly tenant finally does, at the end of their life, you know, you put your kid in there or something. So, example 3. Owner is demolishing a 6-family building in Park Slope, which is part of a larger development site that contains other buildings that have already been emptied. And there's one guy sitting there, and he sees that everything around him's empty, and it's emptier every day. And, you know, he's happy there, and he's counting his money every day as other people are on their way out. So, owner applies for a demolition eviction of the holdover, promising to relocate the holdout in this new building when it's finished. Like I said, I mean, you might have to have some subsidized housing in there anyway. So, that brings me to the relationship between demolition, eviction, and buyouts. I'm thinking that if you've got a guy in there that's watching everybody else fall like 10 little Indians and thinking he's the $17 million guy, when he gets a notice that says, you have 10 days to come and inspect this apartment, that's your alternative housing apartment, and DHCR sends him a copy of your demolition application, it's at least got to make that guy and his lawyer start to think about the fact that, you know, at the end of the day, it's possible I'm just going to be in a rent-stabilized apartment across the street for the rest of my life, and I'm not going to get my windfall. So it's something to think about. There's one other thing I want to say. I get this all the time. People come in, they just bought a building, and the seller just didn't renew any of the rent-stabilized leases because they said, oh, I'll let you do it. And the purchaser says, you know, yeah, I'll do that. Or some contracts, you know, contracts typically say, you can't do anything without the leases, about the leases while we're in contract unless you talk to me about it, and that just never happens. So I get a lot of the time they walk in and all the leases are expired. You should never let the rent-stabilized leases expire because the rent-stabilized lease doesn't protect the tenant. The tenant has all the same rights. They're a statutory tenant. The lease protects the owner because without the lease in place, I can't do demolition eviction because I need that 90 to 150 window. And so if a lease isn't running, it can't end, so then I can't get to the ending period. It's the same for non-primary residents. I can't even do a non-payment in housing court if you don't have the leasing right. So, I mean, I had somebody come in about 6 months ago, and they have like the best non-primary residence case in the world. The woman literally, in her own name, owns like multi-unit buildings elsewhere in Brooklyn, and she's the tenant in this one apartment, and she's running a travel agency out of it. But I can't do anything because, you know, they had to lease it up, and now I got to wait almost 2 years to get to the end of the lease. So that brings me to really my larger point, which is I've been saying to people for years, why didn't you come to me before? Why didn't you come to me earlier? And the truth is, some people have started doing that. I've got a couple of people talking to me about being involved at the acquisition phase. I see a building differently than you see it, or your numbers guy sees it, or your engineer sees it. I mean, I see the tendencies. And what I'm thinking is, it's not only that I can, like just the tip about make sure the leases are in place. Don't let them run just because like you're in contract and moving toward closing. But even more than spotting problems, I think I could be helpful in spotting opportunities. So another thing I get all the time is people come and they say, oh, I know the tenant doesn't live there. I have thousands of ways of knowing that, but housing court will never give the apartment back, which is not true. You can win these cases. So the point of this demolition eviction thing is, and look, people are doing it. It tends to be more a Manhattan thing, but there's no reason why. I mean, so if you know what the elements are, and like I said, they're all, everything I just said, it's all laid out in there in detail, step by step by step. I even have, like I have one of my charts on page whatever that tells you the exact timing. You know, it should open your mind to possibilities. So I'm a little ahead of schedule. But you know what, Jay? Let's do it this way. You come and do source of income, and then we'll do questions. Or should we do questions on this now? Okay, do questions on this now, because I got 8 minutes.
What's the fastest you've seen DHCR approve something like this? Because I know that anytime we get involved with DHCR, it's super slow.
I don't know how to answer it because I'm in the stage of one, I'm in the middle of one, and then another, it worked out the way I said, where it just forced a buyout, and there's so little reported case law. Like I said, this Peckham case was 5 years, but they took it all the way up to make a point. DHCR is slow, what can I say? But I mean, look, the time is going by anyway, and it doesn't cost a lot to put one of these applications in. I mean, it's paperwork, you know, and again, I think it probably would have a salutary effect on the buyout situation. So I can't answer the question exactly. It does say that you can ask for expedited treatment. It says it right in the statute, but I mean that and, you know, whatever. My Metro card will get me on the subway, so go ahead. Okay, the question is, are there similar avenues for commercial tenants in manufacturing districts? There doesn't really need to be because they don't have rent stabilization protection. They're free market, and when their lease ends, you can put them out. Prior to their lease ending, you're just looking at finding defaults. Let me give you a good one because I get this question all the time. The default I've seen that's the most robust right now in the commercial leasing world is insurance. No one understands insurance. And so I'd say 25% of the time, the commercial tenant doesn't even have the insurance in place that they're supposed to pursuant to their lease. And then if they do have it in place, I'd say 75% of the time it's inadequate. Why is this important? Because an insurance default is a non-curable default. And that's appellate case law in both the Second Department, Brooklyn, and the First Department, Manhattan. And that's big. And it's a good, you want to say something? So it being non-curable means this. You don't have to send the tenant a notice to cure that results in a Yellowstone injunction. You can just send them a notice to terminate, which I once did this in Queens, and the guy ran in to get a Yellowstone anyway, and the court signed it. But the point, and it settled. The tenant left eventually. But the point was that it's definitely something, I almost wanted to make a program on that. Potent commercial insurance default to pressure a tenant, lack of insurance. The other thing is, I just want to say one more thing about that. You kind of need an expert to be involved. You need to get an insurance consultant who's not a broker, because a broker will tell you everything, you know, you want to hear. But really, they're insurance consultants, and I've used them in these cases. And, you know, like any expert, they're a little bit expensive, but they can look at the lease and the policy and tell you, no, that's not what you're supposed to have. But sometimes it's just blatant, like they just, oh, you're supposed to have boiler insurance. They don't have boiler. You're supposed to have plate glass insurance. They don't have plate glass. Oh, workers' comp, they're fined by the state, you know, because they don't even have it. So, what do you want to say?
The other thing is, you should check your lease carefully, because if it's not your lease and you bought the building and there was a commercial lease involved, a fair amount of commercial leases have a demolition clause in there. So if you have a demolition clause in there, just make sure and utilize it.
And then the issue becomes, they argue, they say you're not really demolishing it. But that's not an insurmountable one. Any other questions on this before we do source of income discrimination? Okay, oh, okay.
This is not necessarily related to demolition, more on relocation and commercial real estate. When I work with landlord and tenants, each side has a different version of a good guy guarantee or a good guy clause.
That's yours.
Can you speak to, a lot of landlords view it as the landlord being in favor, a lot of tenants view it as the tenant being in favor, saying if I need to surrender my lease, I can do it very easily, which I know is not the case. So how would you view
I'm not understanding the relationship between the question and the good guy clause.
Okay, so the question is, how does a lawyer view a good guy clause?
A good guy clause is quite simply a commitment on behalf of the principal, usually of the tenant, saying that the tenant is going to be a quote-unquote good guy while the tenant is in possession of the lease. So the whole raison d'etre of the good guy clause basically says that it's a commitment by somebody presumably with assets who's connected with the tenant, who's going to make sure that the tenant doesn't jerk the landlord around for rent or other lease defaults while the tenant is in possession. Does that make sense?
No, he's asking, if you're trying to pressure a tenant to get out, a commercial tenant, are you happy, as the lawyer for the landlord, are you happy to see the good guy guarantee, or are you not happy to see the good guy guarantee?
Well,
You're happy.
The good guy clause raises the specter of personal liability on the part of the principal for a lease default on the part of the tenant. So that could be a card if the tenant is in default. But if the tenant's not in default, it doesn't add anything to the equation.
Okay. If you had to answer one way or another, is it landlord friendly, tenant friendly?
Landlord.
Well, it's definitely landlord friendly, and the fact is that there are tremendous variation in the real estate community on the character and quality of good guy clauses. Initially, good guy clauses were invented to prevent tenants from operating within a shell and not paying rent for a year and a half while somebody went through the process of trying to evict them, and then walking out the day before the marshal showed up, having enjoyed the benefit of having a year and a half of free rent. And then the landlord couldn't do anything about it. So the good guy clause was invented to prevent that kind of misuse of the judicial system. Now, good guy clauses are utilized to basically enhance, to surreptitiously enhance security on the leasehold, and to try and find ways to keep tenant principals on the hook for any kind for lease violations.
All right, so that's perfect timing for come do source of income. All right. Let me reset the timer. Oh, thank you.
I'm going to stand over here, if I can get this thing to work. And there we go. All right, so my name is Jay Itkowitz, and we're here to talk about, in this section, lawful source of income discrimination. And that's yes. Now, lawful source of income discrimination is kind of a long-winded way of saying, guys, you can't discriminate against people because they have some kind of governmental funding to support them in paying for the rent. It basically, if you go back to the 1960s, when Congress started passing civil rights legislation, basically Congress was saying that you can't discriminate against African American people in the sale or rental of housing. So they had the Fair Housing Act was passed, and basically gave people access to the federal courts to enforce equal rights for African Americans. And that concept has been expanded to include national origin, and then they passed the ADA Act, so that you can't discriminate against the disabled. And the New York City, in 2008, the New York City Council passed the statute, which is a local law amending the discrimination statutes as it applies in New York to say you can't discriminate against people who get essentially get governmental source of funding to help pay the rent. So what does that mean in practical matters, in a practical sense? Lots of real estate agents, when they're renting apartments and this is really mostly geared towards the rental of apartments. A lot of landlords have had regulations. We're not going to rent to somebody unless they have 6 months, a solid record of employment, unless their their weekly income is 40 times, the annual income is 40 times the, not annual, they have to set up these formulas for 40 times their income, their weekly income, so that they're guaranteed to know that the person can pay the rent. Or they have other requirements, everything that is geared towards your employment income. So what does that do for somebody whose income is going to be covered by the government? So if you take somebody, for instance, with AIDS, the city has a program, it's called HASA, that's the nomenclature, where the city will basically guarantee and pay the rent for somebody who has AIDS who qualifies for that kind of assistance. Now, a lot of landlords don't want to rent to people who have AIDS. They think that, they have an attitude about people who have AIDS. And what the statute does is make that the equivalent of race discrimination. So, and the theory is that if the government is going to pay the rent, that's the best guarantee that you could get. Now, some people might disagree with that because it might come with a panoply of regulations. The HASA program might be in effect today and may not be in effect tomorrow. There may be all kinds of, you have to go, a HASA lease has to be approved by the Department of Social Services, so that might take a couple of weeks. So there are all kinds of, and then the population of people who've contracted HIV statistically may not be considered to be as desirable as people who are making $150,000 a year on a Wall Street job.
You can lose the job, though, too.
Excuse me?
You can lose the job.
Right, right. But the bottom line is, the theory is that the government is guaranteeing the rent. You can't discriminate against somebody on an economic ground. So that's what it does. So who is protected by this kind of regulation? People who receive, let's say, federal assistance, people who receive unemployment benefits. There are any number of programs where people get rent subsidies. And so if you're going to have requirements that essentially discriminate in any way against somebody who has a rent subsidy, and facially all you're doing is saying, we want to make sure you're employed and can pay the rent, then you're going to be in violation of the statute. So how does this come into play, and why does that affect some of the people in this room? Well, if you're a real estate broker, or if you own a real estate brokerage company and you have real estate salesmen who are renting out apartments and they violate the statute, they can create a tremendous problem for the owner of the brokerage company. And why is that? Because the real estate broker, the person, let's say you have 100 real estate agents working for you renting apartments. If one of those people violates the statute, guess what? The brokerage company is responsible. It's a doctrine we call respondeat superior in the law, and it's written into the statute that that the principal is responsible for the agent's behavior, the agent in this case being the salesman. So the only way that basically real estate companies can protect themselves from these kinds of violations is by making sure that every person who's involved in renting apartments understands what source of income discrimination is. So in these materials, we outline the statutes, and we outline some of these procedures. And if you look at source of income discrimination can start in the advertising. So when you go to place an ad, let's say on Craigslist, or you place an ad, classified ad, in the New York Times or any other publication, these publications now basically warn you that source of income discrimination is not permitted. But it's kind of buried, it's not emphasized. So there are still people in the real estate community who do not understand that you can't discriminate against people based upon source of income. And that's why we're here to do this program, because we've had situations where we've been defending brokers, and brokers come in and they're in trouble. One of the things that you might say, well, what's the problem? You know, what's the terrible damage if I turn somebody down because I have a policy that I want to rent to people who are employed, and you wind up discriminating against somebody who's got AIDS? What are the damages? What's the worst thing that can happen? And the worst thing that can happen is that under the law, the plaintiff, if they win, can get what we call compensatory damages. So what's really the damage? If somebody is trying to look for an apartment and they can't find an apartment, and they get turned down because of discrimination, they can suffer emotional distress. And juries can award damages for emotional distress. And that's a jury question, usually, because these things tend to wind up as jury trials. And so if it's up to a jury, who knows? The person can come in and testify as to the grief that they had to live in a hotel, they had to live in an undesirable place, and jury gets a chance to put a value on that. But interestingly enough, that's not the worst damage that you can suffer economically if you get caught in the snare of discrimination of source of income. What is the worst damage that you can suffer? It's attorney's fees. People there are a number of attorneys who bring these lawsuits. And it could take, you could lose a case, the plaintiff could be awarded $15,000, and you could get stuck with a $250,000 attorney's fee bill. And that's even after you pay your attorney to defend yourself. So these are very, very serious ramifications.
So you're saying you have to pay their attorney's fees?
Yes, yes. In other words, you pay for your attorney to defend yourself. You wind up paying the plaintiff $10,000, $15,000, $20,000 for damage. That's if you're found to be responsible. And then on top of that, you have to pay the other side's attorney's fees, because under these discrimination statutes, you're liable for the plaintiff's attorney's fees. So that becomes a very, very serious economic ramification. Another serious ramification would be, and we have one of these cases in our office now, if you are found to be, if it's thought that you might be discriminating against people based upon lawful source of income, and the Attorney General begins an investigation of you, your records for 3 years prior can be subject to a document review, in which case the Attorney General might subpoena all your records and then you have to hire an attorney to defend yourself, then you have to go back through 3 years of records. You have to put 3 years' worth of records together. You have to review them, and then if there's one mistake in there, you might have a problem. So,
Explain that records are applications, Craigslist
Okay.
ads, personnel records.
so what are records?
Email.
Records would include email. Records would include your applications. Records would include your leases. Any piece of paper that might be generated in the leasing process becomes subject to review and subpoena by a governmental agency, or even by a plaintiff in a lawsuit who's bringing these kinds of cases. And these document reviews tend to be tremendously expensive to deal with. Now, just moving on, who is out there looking for lawful source of income violations? So if you place an ad, let's say, and has an employment criteria in the ad, you are inadvertently committing a potential violation of the statute. If you put 2 years' worth of employment, 1 year's worth of employment in your ad, that is suggestively ruling out people who get income not based upon employment. And that not based upon employment might be people who get governmental subsidies. So you could be subject to a lawsuit just by placing a bad ad. So you have to really think about this, because there are lawyers out there who are looking to bring these lawsuits on behalf of people, because they can get fees. It's a fee generation for potential lawyers. In addition, and this is even a more serious problem, there are nonprofit groups who are very, very interested in making sure it's a level playing field so that people are not discriminated against. And one of those 8 nonprofit groups is the Fair Housing Justice Center. The Fair Housing Justice Center, their sole business is to make sure that there's no discrimination in housing. And that means no discrimination based upon race and no discrimination based on source of income. So they're always out there looking to snare landlords and real estate agents to make sure that everybody is complying with the law. And these people are zealots. These are people, a lot of these people went to the best colleges in the country, the best law schools in the country. They don't make a lot of money. What gives them satisfaction is eradicating discrimination. And these people are fearsome to go up against, because they're not motivated by money. They're motivated by their belief in making the system work. And here's what they do. This is the system that they use to trap people and to basically make out a case. They hire actors and actresses to make inquiries. So if somebody gets a report that your company, your owner, your real estate company is committing source of income discrimination or race discrimination or any kind of discrimination that's prescribed by the law, what they will do is they'll hire an actor, and the actor will call up. They'll have 2 actors. They'll use them in pairs. One person calls up and claims to be a member of the discriminated group. So, for instance, let's say I want to see if a landlord is committing source of income discrimination. And I've gotten a report that they're not taking somebody who, let's say, has AIDS assistance from the city of New York. So I call up, and I get on the phone, and I say, I'm looking for an apartment, $1,200 a month, but it's not for me, it's for my cousin. And by the way, he has AIDS, and he's receiving HACA assistance from the city of New York. And if the person on the phone says, you know what, we don't take people with programs, or we don't take people on HACA, right there and there, they have a tape-recorded conversation, which is prima facie evidence of discrimination. How they follow it up, how do they seal the deal? An hour later, somebody calls up and says, I'm so-and-so, I work at, J.P. Morgan. I make $150,000 a year. I'm looking for a one-bedroom apartment in the community. And of course, then the broker says, well, come on out, we'll show you this apartment, we'll show you that apartment, we'll show you this other apartment. Then they have then a paired testing, both tape recorded, one showing discrimination, one showing, assistance. And then they have that, and they can go to town. They now have a federal lawsuit against you. And they bring a federal lawsuit, and federal lawsuits go fast, and they get a jury trial if they want it, and they can really commit a lot of damage by doing that. So that's their technique. So it's not, and if you, let's say, don't do it by advertising, you say, okay, I'm going to be smart. I know about this. I'm not going to do it in advertising. So you don't have any advertising that jumps out at somebody. But you do have the policy. So when somebody appears in the real estate office and says, I want to look at this apartment, and there's an application, if the application contains these requirements, the application then puts you in trouble also. So let's say you know about this. You know now you've had this lecture. You've been here. You now know you can't you can't discriminate against source of income. So you have a policy, but it's an unwritten policy. And your unwritten policy, you have disparate treatment. You treat one group differently than the other group. Treat the HACA person or the person who's getting governmental source of income differently than you would treat the investment banker from J.P. Morgan. That's a little bit harder to build, but again, they send in the people with the secretive tape recorders, and they can build a case that way. So, does that mean that you have to accept every person on HACA? No. As long as you have a non-discriminatory reason for saying no, you can do that. So I'll give you an example. You can still require a credit report as part of your application process. The credit report might cost $25, and people on governmental assistance may not want to spend that money, or if they do, what is the credit report used for? It's not just used for showing income. It's used for showing whether somebody, if somebody has a litigation history, it's likely going to show up in a credit report. If they have a number of judgments against them, that might be a factor that you can utilize to say no. But as long as you're not saying no because of the source of income, you're okay. So you still can use judgment. You don't have to accept everybody.
But they also look at, if you've never rented to anybody with HACA, and they're reviewing your applications and they see that 10% of your applicants got government benefits and you've never made a deal with any of them, that becomes evidence as well. They've looked at that too in our cases.
Well, they can look at that. It becomes a much harder case. Look, as a practical matter, if you take source of income out of it, there can be reasons to say no that are not based upon source of income, and that's really all the government can ask for, and that's all that the anti-discrimination statute can really get. So it becomes a harder issue of proof, and I'm not saying we're not here to try and school you into how to say no. We're just saying that just because somebody is getting governmental assistance, that doesn't mean you have to accept them, no matter what their background, no matter who they are, no matter what kind of people they are.
Also, what we've seen in two big cases we've had is, I find that a lot of real estate agents don't have a well-documented, they don't have a lot of times it just comes down to systems in place in the office, and as I'm reviewing piles of rejected applications, there's no way for me to tell, or anybody to tell, why were they rejected? So if there's no reason, and of the rejection applications, a higher percentage are people that got government programs, the bottom line is you can't do this. You just can't do it.
Here's one of the things that you run across. And now I'm addressing this really to the real estate broker. The broker who's renting the apartments, it's hard, in this business, it's hard to get listings. Really, success in being a real estate broker depends upon getting listings. And in order to get listings, you want to cater to the owner. And if the owner says, look, I don't want to rent to a certain kind of person, there's a tendency for the broker to want to accommodate the owner. However, under these statutes, if you accommodate the owner by committing an act of discrimination, you're going to take you could take a very hard fall for that. So, but that being said, as the real estate broker, all you're obligated to do is to show the apartment and to not refuse to show an apartment, not to refuse to put in an application. If you do all of that, if you put in somebody's application, if you show them an apartment just like you would show the investment banker the apartment, if you have them fill out the application just like you would have them fill out the investment banker would fill out the application, and you pass it along to the landlord, you're in the clear. You've done everything you're supposed to do. Then the only person who has potential liability is the owner. The person who's actually making the decision on whether to accept this application or that application. And then if you're the owner and you want to stay in the clear, you just have to make sure that you document in your records that you're not making a decision based upon an unlawful basis.
Let me just say one thing, why this is really tricky. We defended somebody in one of these cases, and she had a real estate agency in Brooklyn. And she knew that she had certain owners that just weren't going to deal with her HASA applicants, and other owners who were happy to take the HASA applicants. They like getting the money from the government. So because she thought that her experience was that if you took a HASA applicant and brought them to a building where they were unfriendly to that the landlord was never going to make the deal, she sort of set up two systems within her office, a bifurcated system that, in essence, really ironically fast-tracked the HASA applicants into housing that they were happy with. And she actually, for such a small agency, had one of the highest percentages of placement rates for people who got HASA. So in her mind, she was also doing a good thing. You see what I'm saying? But the point is that that's not what mattered. The point is that according to the letter of the law, it just can't work that way.
Yeah, the bottom line is that the court found that to be a segregated system. And if you want to get that, have that understanding in your mind, it would just think about it, and it's easier for people to understand based upon if you do like a racial analogy. If you have an owner, let's say, who says, I'm not going to rent to Jews, or I'm not going to rent to African Americans. You, Mr. Real Estate Agent, you get me people, but don't get me Jews, don't get me African Americans. Most people would be offended by that request. Might not even want to do business with that person. Certainly in New York City. The South, certain parts of the South, maybe today, they wouldn't care. But in New York City, clearly, that's unacceptable behavior. Most real estate agents are going to be turned off by that. Well, you have to think about it the same way when it comes to source of income. That's what the statute does. It makes the discrimination against people who get governmental funding for their apartments the same as if you were discriminating against somebody based upon their being Jewish, or based upon their being Christian, or based upon their being African American. And once you have it in your head that that's what the government is talking about, it's easier to deal with it, to understand it, and to understand how the statute might apply. Now, we've talked about the implications of what happens.
You have
Let-
3 minutes.
Let's talk about how you can, if you're, let's say, running an agency, real estate agency, how you go about staying out of trouble. The first and foremost thing you must do is in your advertising, you must say that we do not discriminate based upon, illegal criteria. And by the way, any complaints of discrimination should be directed to, and you give a name and a phone number. So right there, you've put in protection so that if any of your agents are committing discrimination, you've created a mechanism for you to investigate and for you to prevent it. A second thing that you can do is make sure that you have educated your brokers on this issue. Because even today, people come to me and they don't even know about it. And if you're a real estate broker, or a real estate salesman, you're charged with knowledge of the law. That is, your ignorance is not a defense. So you need to make sure that all your brokers, all your salespeople know and understand that you can't do this, and you could probably get them to sign an acknowledgement that they've taken this course, that they understand it, and they understand that if they commit an act of discrimination, that their employment can be terminated. Now, in preparing this article, or this lecture, I looked at the statute carefully in a way I hadn't looked at it before, and I just want to share it with you. There's a general understanding in the community, and it's an inaccurate understanding, that this statute only applies to buildings that have 6 units or more. So if you speak to people in the real estate industry, they'll say, oh, this doesn't apply if it's a 5-family or less. But that's not exactly true, because what the exception is, it says, yes, it doesn't apply if it's a 5-family structure or less, except, and this exception is an exception that in most instances you can drive a truck through. So you really have to be aware of that. The exception says that if the person or the company which is renting the apartment has any other housing projects which have 6 units or greater, the exception doesn't apply. So if you're, let's say, an owner and you own, a 100-family building, and you have a 5-family building, or you manage a 5-family building and you manage a 100-family building, you're subject to the regulation even in the building that's 5 units or under, because you own or control other units that are greater than 6 families. So I would say, I'll take a question. I would say that there are many, many people walking around there thinking they're not subject to this statute because it's a 5-family building or less, when the exception clearly states that if you own or control a building that has more than 6 families, you're still subject. Yes? Excuse me? Well, typically, real estate projects are owned by different LLCs, even though it's common ownership. You know what? Maybe you could take that position. But again, it's a dangerous position to take, because Fair Housing Justice Center or a lawyer representing a plaintiff, if they know that you own 2 different companies under 2 different names, but it's controlled by the same person, is going to make an argument that you're subject to the statute. And then you're going to spend some serious money defending it, and you still may have the liability. So it's a lot of what we do is risk avoidance. Sometimes the cure is worse than the disease. Anybody else? Thank you.